Thank you, Louise, for those kind comments. Thank you. It's a great privilege to have been invited to speak at this conference, populated as it is with so many distinguished speakers, not least of whom was the last speaker, the Chief Justice of the Federal Court. I follow him as your next speaker, and if he was your main course, I regret that I am no fitting dessert and am perhaps no more substantial than a solitary after-dinner mint. This is the second time, as Louise has quite rightly pointed out, that I have addressed the Society, and I feel I should warn you that on the last occasion, at the end of my address, one of the conference attendees was found lying on the ground at the back, fast asleep. Now, there's been some confusion has arisen about the title of my address, which the schedule records as being the Judicial Burden in the 21st Century. What in fact happened is that when I was asked at the last minute to prepare a paper for this conference, that in fact was my reaction. Oh no, the judicial burden. Judges are often asked to deliver papers. It's not just a burden, but a potential nightmare. 67 years ago, Sir Owen Dixon delivered a paper at Harvard University entitled Marshall and the Australian Constitution. The occasion was a conference to mark the bicentenary of the birth of that pivotal Chief Justice of the US Supreme Court, John Marshall. Other speakers included Chief Justice Earl Warren, Justice Frankfurter, who was Dixon's great friend, and Lord Evershed, who was then the Master of the Rolls. The main reason for Dixon's visit to the United States was to receive Yale's Howland Prize. The Harvard speech, perhaps much like my own today, was a bit of a tack-on, but the speech he had earlier delivered at Yale was not. It was his famous oration entitled Concerning Judicial Method. But it is his paper on Marshall that I want to advert to today. In Dixon's speech about him, he quotes what Oliver Wendell Holmes said about the Marshall Court. Quote, "They were an innocent lot and didn't need caviar for luncheon." That, I think, is a very great understatement. For John Marshall really is the founding father of all those judicial branches around the world which are obliged to traverse a federal system of government. For a society committed to the rule of law as this is, it's worth taking a moment to remember his great achievements. Dixon was certainly of the same view. In his paper he said, "What could be more natural, what could be more right than to make a grateful appropriation of Marshall's more famous judgments to Australian use?" The two most famous and influential of those judgments were, of course, Marbury and Madison, which many of you will know about, which was decided in 1803, and McCulloch and Maryland, which was decided in 1819. Both were the subject of Dixon's paper. We begin with Marbury and Madison. It has been cited on 51 occasions by the High Court. It is at least the main reason for the existence of Section 75(5) of the Constitution. Most of us know in this room what it decided, but today I wanted to reflect momentarily on the truly unbelievable circumstances that led to it being decided. Now, in the dying days of the Adams administration, the Judiciary Act and the District of Columbia Organic Act were passed into law. These enactments, amongst other things, established for the first time an inferior federal court with circuit judges and divided the District of Columbia into two counties, one of which was called Washington and the other Alexandria. These laws enabled President Adams to appoint 16 Federal Circuit Court judges and 42 justices of the peace, 23 of which were to serve in Washington County and 19 in Alexandria County. This was, on one view, a surprising number of new justices, given that in 1800 the combined population of Washington and Georgetown was 6,203. The Judiciary Act also reduced the number of justices of the Supreme Court from 6 to 5. Many thought that Adams was seeking to deny to his successor, President Jefferson, an ability to nominate his own candidate to the Supreme Court. In that respect, perhaps things have not changed much in that great republic. To say the least, the acts were controversial. The Federalists, who were led by Adams, admired them. The Republicans, led by incoming Jefferson, decried them. At that time of his life, Jefferson, of course, hated Adams, and he was no fan of his distant cousin, John Marshall. It is perhaps somewhat ironic that when Marshall needed to commence his law practice in Richmond, Virginia, following the Revolutionary War, he did so by purchasing his cousin's already established law practice. That cousin had in turn previously acquired that practice from Jefferson himself. The connections between the two men continued, for upon assuming the presidential office in early 1802, it was Jefferson who found a stack of about 42 signed judicial commissions on the desk of the outgoing Secretary of State. That secretary, in what must have been a mad rush to get things done, had failed to deliver the commissions to the new Justices of the Peace. Who was that Secretary of State? Well, it was none other than John Marshall, who had been Adams' Secretary of State and then had remained in that office for a month following his appointment as Chief Justice of the Supreme Court of the United States. And so the seeds were sown. Very few people in those days wanted to be a Supreme Court Justice. It had a very small docket. That was because there was very little federal law to administer. It mostly did admiralty law. In its first 10 years, it decided only 63 cases. Marshall's appointment would have been seen by many as a backward step. That explains why Alexander Hamilton had earlier refused an offer from President Washington to be a Chief Justice. If only he had said yes, he might have led to an old age, but then again, we would have been denied a popular musical. The Supreme Court justices, to keep busy, rode the circuit, there being no inferior federal court prior to the Adams Act. And they stayed in basic country taverns and often had to share a flea-ridden bed with strangers. I can tell you, I wouldn't do that. No one knows why Marshall gave up such a promising career in those circumstances. But back to those judicial commissions. Jefferson instructed his then acting Secretary of State, Mr. Levi Lincoln, that he was not to deliver them. Jefferson formed the view that until delivered, the appointments had not been perfected. Jefferson was also of the view that they were all Federalists, so his political opponents. Eventually, about 25 of the commissions were in fact served, some on Republican-aligned men, some on Federalist-inclined men, leaving 17 disgruntled almost judges who were not served at all. One of these was a man called William Marbury, a prominent Federalist from Maryland, who he thought had been appointed validly a Justice of the Peace. But Jefferson wanted more than this. In April 1802, Congress, now controlled by the Republicans, repealed the Adams Judiciary Act and instead passed their own Judiciary Act. It eliminated the new circuit court judges, restored the Supreme Court to 6 justices, and then it did something remarkable. It cancelled the Supreme Court's entire sitting for the balance of 1802. Section 1 of that act was in these terms, and I shall read it to you because it would not pass constitutional muster nowadays. It said that from and after the passing of this act, The Supreme Court of the United States shall be holden by the justices thereof, or any four of them, at the City of Washington, and shall have one session in each and every year to commence on the first Monday of February annually. Now, it was widely suspected that this provision was inserted to prevent the Supreme Court from hearing any immediate challenge to the Jefferson Acts. The Supreme Court justices, unable to sit together until February 1803, and after much internal debate, decided they would have to only do one thing, and that is ride the circuit again. And in his spare time, John Marshall also wrote what is said to have been the most uninspired biography of George Washington. It was in this context that February 1803 came to pass. The cause of action that William Marbury filed was the seeking of a writ of mandamus to force the new Secretary of State to deliver the commissions. The action took place in the original jurisdiction of the Supreme Court. Section 13 of the Judiciary Act 1789 gave the Supreme Court jurisdiction to issue writs of mandamus, quote, in cases warranted by the principles and usages of law to persons holding office under the authority of the United States. Marbury was represented by a man called Charles Lee, yes, one of the Virginian Lees, a former Attorney General who, interestingly enough, had refused to be appointed as one of those new Circuit Court judges by John Adams. James Madison, now the new Secretary of State, refused to attend personally and also refused to send a lawyer to represent him. President Jefferson told everyone he knew at the time that he would ignore any order requiring delivery of the remaining commissions. But there was a much more immediate and practical problem that William Marbury faced. He had to prove that his commission existed. Now, John Marshall, sitting as Chief Justice, he knew that it existed, but he couldn't give evidence about that. So the question was, how would they prove this? Charles Lee, first of all, asked the Senate to provide the commissions or confirm their existence. The Senate, dominated by the party of Jefferson, refused. Then Lee called the chief clerk of the State Department as well as his assistant to give evidence. They had a lapse of memory and could not recall the commissions. Lee then called Mr. Levy Lincoln, the former acting Secretary of State. What did he do? He invoked the Fifth Amendment and refused to answer. Eventually, though, he conceded in writing that there were commissions, but he couldn't remember whether William Marbury was one of the people appointed. What did they do then? Well, Lee relied upon an affidavit sworn by another one of the new Circuit Court judges. Who was that person who swore the affidavit? Well, it was none other than John Marshall's brother, James. And the reasons for the decision to not disclose that identity, but no doubt the affidavit was received into evidence without opposition because, of course, Madison didn't send a lawyer to object. All the reasons say about this remarkable affidavit is the following, and I quote, "It appears from the affidavit that, in compliance with this law, a commission for William Marbury as a Justice of Peace for the County of Washington was signed by John Adams, then President of the United States, after which the seal of the United States was affixed to it, but the commission has never reached the person for whom it was made out." Now, we know from other sources, not the reasons for decision, that James Marshall claimed that he had been asked to deliver 12 commissions, one of which was, I assume, that of Marbury. And in this strange way, the commission was proven. The court delivered its verdict 4 days later, not in a courtroom, but in the lobby of a hotel, Stell's Hotel. It did so because one of the justices was unwell, and like all the other justices, they all stayed at Stell's Hotel. We know for a fact, anecdotally, that it was commonplace for John Marshall to offer Madeira to the other judges. The rule was that if it was raining, we would drink Madeira. And if it was not raining outside, John Marshall would say, well, it's raining somewhere, so we can have some Madeira. Now, we all know what happened. The court decided that Madison had acted illegally in failing to deliver the commissions. Pardon me. But to everyone's surprise, the court refused to give the remedy of mandamus. That was because Section 13, which I read out to you earlier, was found to be unconstitutional insofar as it purported to give the Supreme Court original jurisdiction to issue writs of mandamus in circumstances that went beyond Article 3 of the United States Constitution. Section 2 of Article 3 at that time was relevantly in these terms: in all cases affecting ambassadors, other public ministers and consuls, and those in which a state shall be a party, the Supreme Court shall have original jurisdiction. Marbury was not an ambassador or a public minister or a consul. The court therefore had no jurisdiction because Section 13 went beyond what was authorised by the Constitution. And so, for almost the first time, the Supreme Court decided that a section of an Act, validly passed by the people's representatives, was nonetheless invalid. I say almost the first. Apparently the Supreme Court of Rhode Island had done it 10 years earlier in similar circumstances. Now, there has been much speculation in recent times as to what had really gone on. It's been suggested that mandamus could have been issued out of the lower district court. If so, why did Charles Lee, an experienced lawyer, why did he seek mandamus from the Supreme Court rather than the lower court? Was it because, as some have speculated, if he had issued it in the Circuit Court, his only witness then to prove the Commission's existence might have been John Marshall himself? Jefferson's reaction to the case was incendiary. Marbury and Madison was, quote, a gratuitous opinion, which should be denounced as, quote, not law. Writing, ironically enough, to Abigail Adams, that's Mrs. John Adams, about a year after the decision was published, Jefferson observed, but the opinion which gives to the judges the right to decide what laws are constitutional and what are not only for themselves in their own sphere of action, but for the legislature and executive also in their spheres, would make the judiciary a despotic branch. Writing 6 years later, in 1810, and still unable to forgive what the court had done, Jefferson referred to Chief Justice Marshall's, quote, twistifications in the case of Marbury. By 1820, still angry. He was 77. He described Marshall as, quote, crafty, and said that, quote, a judiciary independent of the will of the nation is a solecism. In 1823, he's still angry. He writes this: the court determined at once that being an original process, they had no cognizance of it, and therefore the question before them was ended. But the Chief Justice went on to lay down what the law would be, had they jurisdiction of the case, to wit, that they should command the delivery. The object was clearly, Jefferson writes, clearly to instruct any other court having the jurisdiction what they should do if Marbury should apply to them. Besides the impropriety of this gratuitous interference, could anything exceed the perversion of law? Jefferson clearly held grudges. In contrast, Marshall, the man who supplies the Madeira, was renowned for presiding over a collegiate, cooperative and friendly court. The numbers bear this out. During his long tenure, he wrote 547 judgments, or as they call them in America, opinions, of which 511 were unanimous. The total number of judgments, or opinions, delivered during his time was 1,129, and all but 87 were unanimous judgments. In his paper on Marshall, Dixon expressly acknowledged the influence of that man on federal judicial power in this country. He wrote, to the framers of the Commonwealth Constitution, the thesis of Marbury and Madison was obvious. It did not need the reasoned eloquence of Marshall's utterance to convince them that simply because there was to be legislators of limited powers, there must be a question of ultra vires for the court. Dixon also observed that Marshall's actual decision in Marbury was not accepted by the founding fathers. That is because we got section 75(5), which gives my court the ability to issue mandamus generally. The convention debates record that Marbury was discussed often. Sir Edmund Barton described Marbury in these terms: when the United States Congress tried to confer an original jurisdiction upon the Supreme Court of the United States, it was held that as there was no such jurisdiction conferred by the Constitution, it could not be conferred by Act of Congress because such an act was outside the Constitution. For that reason, the statute was held to be void. Barton went on to argue that we needed section 75(5). He said it might be held, if we don't have such a provision, here that the court should not exercise this power, and that even the statute giving them the power would not be of any effect. And I think that, as a matter of safety, it would be well to insert these words. Now, not everyone at the convention admired Marbury. Mr. Kingston opposed the insertion of the proposed power in section 75(5) because he rejected the notion of, quote, implanting in the Constitution a provision by which federal courts would have any control over executive acts. He was concerned that conferring such a jurisdiction on the High Court could result in the power being, quote, exercised to the very great detriment of constitutional government. A constitutional declaration, he said, quote, that the judiciary should interfere with the executive would be a retrograde step which cannot be defended. But it was Isaac Isaacs at the convention who correctly prophesied as follows, and I quote, "As in America, so it will be here, that the makers of the Constitution were not merely the conventions who sat and the states who ratified their conclusions, but the judges of the Supreme Court, Marshall, Jay, Story, and all the rest of the renowned judges who are pronounced on the Constitution have had just as much to do in shaping it as the man who sat in the original conventions. I therefore think that at the beginning, we should take the utmost care to establish a judiciary to effect the work we are here preparing." Can I now briefly turn to McCulloch in Maryland? The case established the superiority of federal government over the states in the United States and thus cemented that republic at least until the start of the Civil War. The background to the case is illuminating and reflects those early processes by which that young republic sorted out relations that would need to endure between the states and the federal governments, an experiment never tried on such a scale before. We start with that man, Alexander Hamilton, again. He was instrumental in the establishment by a law of Congress in 1791 of the first Bank of the United States. The Republicans were opposed to it. They argued that the Constitution did not authorise the passing of a law of that kind. They feared the centralisation of power. Under President Madison, the bank was allowed to lapse in 1811. That led to an explosion in the growth of state banks being created, all printing their own money. And then with so much paper money circulating in the country, of course, the result was crippling inflation. So in 1816, Congress really had no choice but to re-establish the bank to be called the Second Bank of the United States. But the states didn't like it, and eventually Maryland imposed a stamp tax on all banknotes issued by the Second Bank. Once again, stamp duties at the heart of great constitutional change. Now, James McCulloch was either the manager or the cashier of the Baltimore branch of the Second Bank. He declined to pay the stamp tax, and so the dispute made its way to the Supreme Court. The Marshall Court upheld the validity of the law which established the bank. The law was authorised by what is known as the Necessary and Proper Clause, found in Article 1, Section 8, Clause 18 of the Constitution. In deciding that the law establishing the second bank was necessary and proper, Marshall wrote a famous dictum which is reproduced in Dixon's paper and which I will read to you again. We have an equivalent to the necessary and proper clause in our Constitution about incidental power. He said, "Let the end be legitimate, let it be within the scope of the Constitution, and all means which are appropriate, which are plainly adopted to that end, which are not prohibited, but consist of the letter and spirit of the Constitution, are constitutional." The Marshall Court secondly decided that the states could not tax a federal agency. That was because the federal agency derived its ultimate authority from the Constitution and the people of the United States, which was the superior organ of that state. That doctrine greatly influenced the early High Court. Incidentally, James McCulloch appears to have not been a very saintly man. After the decision was handed down, he was indicted for stealing $1.4 million. But we remember him from McCulloch and Maryland. Following the handing down of the decision, once again, there was great opposition to it. For example, the Virginia legislature passed a resolution, quote, condemning the decision and instructing Virginia's congressional delegation to mount a campaign to curb the court. Well, that didn't work. McCulloch and Maryland has been referred to by the High Court in 50 cases. The first was Demden against Pedder. It's the sixth case ever published in the Commonwealth Law Reports. Many of you will be familiar with it. It will be recalled that it concerned a failed attempt by Tasmania to impose. What was it going to impose? That's right, stamp duty on all receipts, including those given by federal authorities, in this case for wages. The court, comprising of Sir Samuel Griffiths, Barton and O'Connor, said this: "We have had the benefit of considering numerous decisions of the Supreme Court of the United States upon analogous questions arising under the United States Constitution, beginning with the celebrated case of McCulloch and Maryland, in which Chief Justice Marshall, delivering the unanimous judgment of the court, enunciated the doctrines which have since been accepted as establishing upon a firm basis the fundamental rules governing the mutual relations of that great republic and its constituent states. Their Honours then said, we are not, of course, bound by decisions of the Supreme Court of the United States. But we all think that it would need some courage for any judge at the present day to decline to accept the interpretation placed upon the United States Constitution by so great a judge, so long ago, and followed up to the present day by the succession of great jurists who have since adorned the bench of the Supreme Court at Washington. So far, therefore, as the United States Constitution and the Constitution of the Commonwealth are similar, the construction put upon the former by the Supreme Court of the United States may well be regarded by us in construing the Constitution of the Commonwealth not as an infallible guide, but as a most welcome aid and assistance. Now, the reference to having some courage was perhaps a reference to Sir Isaac Isaacs, because as we all know, in 1920 we had the engineers case. Some people think that the engineers case overruled Demden and Pedder. It didn't. It overruled its reasoning. It upheld the result. Marshall's dictum from McCulloch nonetheless remains a foundational expression of federal judicial power. The actual dictum, which I read out to you earlier, has been quoted on 19 occasions in the reasons of the High Court. These have included some of the most complicated constitutional disputes that have come before it. For example, Justice Gummow and Hayne endorsed the dictum as an expression of the, quote, generality of the incidental power, close quote, in our Constitution in Pape against Commissioner of Taxation. The most recent citation was by my predecessor, Justice Nettle, in 2020, in a case called Private R against Cowan. Chief Justice Marshall surely could not have foreseen the breadth and depth of legal and constitutional conundrums that judges must deal with in the present day, but it is telling that the dicta that I have canvassed continue to be applied and relied upon 200 years later and on the other side of the world. Few statements of constitutional principle have proven as timeless or as adaptable. His influence on the federal judiciary of this country has been immense. That influence is even more remarkable when one considers the historical vagaries of his ascension to the court. If Marshall had turned down his nomination by John Adams, or opted to stay in a more established role in the executive, who can say if federal courts of the United States and of this country would have developed in the same way? But he did accept the nomination, and notwithstanding the torrent of unrequited animosity from Thomas Jefferson, perhaps a better architect than a politician, he set his mind to establishing an impartial and fair federal judicial system. Dixon put it best and most succinctly in his paper when he observed, "His judgments have that rarest of properties. When you read them, they appear always to be right. It is a sufficient explanation of why they have carried so far in time and space." Thank you very much for listening to me today.
Thank you, Justice Steward, for that terrific, important and amusing romp through 3 centuries of possibly the most important cases in America and Australian constitutional law. Now, Justice Steward did allude to the fact in his opening remarks that it is dangerous territory for a judge to even deliver a paper, but we have some time set aside for questions. And so if anyone has a question, I have two questions up here, then Justice Steward will be happy to entertain those questions. This is dangerous. James Allen.
Thank you. Well, I just feel like I have to say something on behalf of Mr. Jefferson. My memory off the cuff was that the Federalists had brought in the Alien and Sedition Act, and I'm sure Mr. Marshall had something to do with that, and they were rounding up innkeepers, and it's one of the most brutal anti-free speech pieces of legislation. You wouldn't let Premier Dan Andrews anywhere near it. It might give him ideas. And I think it was in that context of the complete politicization, which the judges did not override during the Federalist administration because they were all Federalists. It was at the turnover after having lived through at least I think it took 2 years to get rid of the Alien and Sedition Act. And so, although I agree, and it was a very great talk, but you can understand the incredible vitriol that Jefferson and Madison would have had for the administration that brought in what probably is one of the worst pieces of legislation in American history, I would say.
I did say the circumstances of Marbury and Madison were unbelievable, and they are unbelievable because we wouldn't see anything like that in this country. But what is also unbelievable is that at no stage did John Marshall think to recuse himself, even though he was the one who failed to deliver the commissions. And he had a conflict because he had been behind the commissions and could give evidence about them. At no stage did he think of recusing himself. But as for the Aliens and Seditions Act, I agree with you. I think even John Adams regretted endorsing it. I suspect when Marshall came back from France to say that the first thing the French said to him in the negotiated treaty was, "Where's the bribe?" He thought he was in dangerous times. And that's all I can say in defence of that act.